I once taught that as a graduate course, as a matter of fact, but that's before I knew any ethics. You have to do this course before you know any ethics. Everybody does special problems, but that's like Phil Donahue.
Problems in nursing, problems in medicine.
On whose show I once was, in fact. Many years ago when he was in Dayton and he was just a little nothing on a radio station.
Oh, good grief.
But the only thing I can think to do after we're through with this, if anybody's still willing to come, is to do the metaphysics from the start as a course. But I have to warn you, I already cherry-picked the best stuff out of it when we did what was published as a recording called The Foundations of Metaphysics. So a lot of it will be repetitive.
Would be?
Will be. Will be.
Oh, will be.
Yes. Some of it would be, some of it won't be. I depend on the faultiness of your memory.
It's not such a problem these days, unfortunately.
It isn't for me either, unfortunately. So, all right, we just got done with warfare, and what we're going to do tonight is not exactly in your notes. At least to begin with, we're going to deal with the parallel between just war theory and economic strife. So what we're really dealing with is the question of the right of workers to strike. I'm not directly going to get into the theory of unionization as such, and of course remember this is philosophy, not theology, so it isn't incumbent upon us to be studying the social encyclicals that deal with the question of organization of workers. But what I'm concerned with particularly is what are the principles that justify something like a strike? And again, it's always good to realize where this material comes from, because really we're taking it from the just war theory, which remember is taken from the principles of self-defense, which in turn ultimately reduces to the right of a being to fulfill its obligation towards last end, which brings us right back to the metaphysics, the context in which the creature is found, given a nature by God and therefore ordered to its end, and in the case of rational beings, to seek that end by choices. So it always comes back to being, which is why metaphysics is so relevant. And of course also it entails the application of double effect. So, an unjust aggressor, just as in warfare, is never justified. In the context of labor relations as well. You're never justified to start a war without sufficient reason. Now, what would be the sufficient reason? There are certain minimum things which any employer owes to an employee. But even there, bear in mind we're talking about full employment. If you're talking about somebody that you're hiring on a part-time basis, you may be serving the great good of giving a young person an introduction to work experience, which they need in order to form their own abilities and also to give them a resume with which to obtain a full-time job. And that, of course, is one of the biggest arguments against the minimum wage, isn't it? If you have a minimum wage, that means that the employers cannot contract with somebody who isn't looking for a full-time job in order to enable them to get some work experience and perhaps some income which they consider wonderful. I know when I first started working some years back, I was working as an usher in a theater, and it was considered one of the most plush jobs that a high school student could get. I was paid the kingly sum of $2.10 a shift. That covers 3 hours. That's 70 cents an hour. And I did that for about 5 years. I finally worked my way up to being the temporary manager on Sunday afternoons, for which I got $5. And a shift, yes. And this was really wonderful, because for somebody who basically had room and board through parental oversight, this was a wonderful way for me to obtain spending money and to learn how to spend money, to learn how to earn money. So if they were bound to give me a minimum wage, which was, I don't know what would be the corresponding amount at that time, but if it were even $3 or $4 an hour, it probably would have been prohibitive from the standpoint of the theater. It's better to have a job than none at all. But here, what we're going to be talking about is full-time employment, people who are trying to earn their living by means of being an employee. And in that context, they require what is called a just wage. And employers have an obligation morally to pay them a just wage. And that means a wage sufficient, basically, to care not only for themselves materially, but also for a spouse and children. And possibly even to save a little bit up for their old age. Remember, we didn't always have social security. That was something invented during the 1930s so that FDR could say that a number of people were already retired and therefore we didn't count them among the unemployed. See, if you became retired because you're on Social Security, then you're not unemployed and therefore you're not out of work, even if you can't live on what you're getting. But in principle, if an employee is being denied a just wage, then it is possible that it would be justified to withhold one's services, which is basically what we mean by a strike. Strikes may be direct. That, of course, would be the employee himself stopping work. Sympathetic, you're on strike, I sympathize with you, so I'll go on strike too. Or it can even be a general strike, which is really a political act of war, and I would say not justified. At least unless you're prepared to stage a rebellion, which is what it really would be. A direct strike, which is what we're mostly concerned about here, is justified, just like war, according to the principle of double effect. First of all, when one engages in a direct strike, what you are doing is not per se evil. You are simply ceasing work. It's not a moral sin to be not willing to work. But of course, remember, you have an obligation where you've contracted with the employer to fulfill that obligation unless he is denying you a just wage or human living conditions. Cessation of work to be licit must be organized. In other words, you can't just take off for the afternoon because you don't like your boss. It must be based on just demands, and it must be in accordance with appropriate circumstances, specifically no bloodshed. No evil means may be used to obtain a good end. The good effect of striking is to induce the employer to render justice to the employee. The bad effect is the economic loss to the employer. But what I want us to understand here is we're using double effect, and what we're talking about is perfectly analogous to just war theory. Strike in the economic order is analogous to warfare in the political order. And that's why it is not to be undertaken lightly. It must not be done because one intends evils to result. In other words, although you may tolerate, and unfortunately the employer is going to lose income, at the same time you mustn't revel in the thought that he's going broke. And of course, frankly, if you drive him into bankruptcy, which some unions have done, how does it serve the purpose of the members of the union? In which case, of course, it's illicit, it's immoral. The only thing that you must seek would be just wages and proper working conditions. Again, there must be due proportion between the purpose of the strike and the needs of the industry in which you're working. In other words, the needs for a strike must be greater than the harm done to society by stopping that particular industry or company. And there again, one has to be very concerned. If you stop something like the post office, that's pretty critical to the entire nation. So if you're dealing with a critical industry, or say a critical industry in time of war, that would not be licit. And certainly never are you permitted to strike if you're in the Army.
Or the Navy.
Or the Navy, yes, understood.
What about hospitals?
Well, I think you have, forgive the pun, a grave problem with striking a hospital. I mean, the part of the difficulty we have today is that everybody thinks you can strike for anything and there are no rules. What I'm trying to say here is there are some rules. You have to reflect very carefully as to whether what you're doing, if you engage in a strike, whether it is morally justified, whether it's morally licit. What kind of things would be a just cause for striking? Well, too little pay that doesn't meet the requirements of a just wage. Too long hours, physically impossible to do practically. Brutal treatment. Obviously, we had problems at the turn of the previous century where you had women and children being forced to work inordinate hours, and children being forced to work when they ought not at all, for which it was necessary to pass legislation to even make it illegal. And there is a proper function for government in passing legislation to prevent such misuse of human capital in that fashion. Moreover, a strike has to have proper authorization. That is to say, it has to be based upon a free and unintimidated vote of the members of the union. I mean, too often we see people being coerced into voting for a strike. Also, you can't have a wildcat strike, because a wildcat strike certainly isn't thought out. You know, it's just one or two or three people throwing down their tools and walking off the assembly line, and everybody goes off in sympathy. That is not voted upon, it's not thought out, it's lacking the proper requirements for an ethical judgment. It must also, to be a legitimate strike, be, just as in the case of war, the last resort. After things like arbitration, mediation, cooling off periods, fact-finding boards. I mean, after all, in terms of diplomacy, you go as long as you possibly can before somebody fires the first shot. Warfare is the failure of diplomacy, and a strike is the failure of honest and sincere negotiations between worker and employer. Also, evidently, the only right means that may be used would be work stoppage and persuasion. That means no injury to persons or property. And I mean, when you think of how strikes frequently are conducted, this is describing what ought to be, not necessarily what is. Employers, in their defense, can engage in what's called a lockout, whereby they say, if you're not coming to work, we just lock everybody out. But again, that has to be only used in the case of an unjust strike. See, the logic of it. Boycotts of products can be justified on the same basis as strikes. Again, you have to have a legitimate reason for boycott, but obviously there's nothing that says you have to buy a product. You don't have to buy a certain brand of toilet paper if you don't want to for any reason whatever. But a boycott is an organized attack upon a company. And you have to be concerned about things like, I'm trying to think what they call it, a third party type strike, where I was, what do they call that? No, I'm trying to think of it, the technical term. You'll understand it better when I describe it, because I ran into one. When I was running for the school board down here a couple years ago, one of the gentlemen that I was that I was running with as candidates for the board was attacked by the teachers' union for some things that they had grievance with him, and he was himself working for a company that supplied some kind of product for other companies. So what the teachers' union did was to organize a strike targeting his customers, not targeting him directly, but his customers. So they were becoming the victims of a billiard shot, as it were, in terms of the process. This is hardly a legitimate kind of thing to do, because you're punishing people that are completely innocent in order to try to destroy the business of the person that you are objecting to, which frankly they had no business objecting to in the first place, because all he was doing was running for school board seat, and the proper answer to that is don't vote for him. George?
What you're talking about, I think, is a secondary strike?
Yes, that's what it is. It's a secondary strike.
I thought, too, it's worth mentioning, in the 1930s, the Ford Motor Company employees went on strike for, usual reasons. And they took the people especially who worked in the foundry, took very special precautions that the furnaces would be cooled before they went out on strike, so that there would be otherwise there would have been danger from a too rapid cooling.
Right.
The brick linings would crack.
Absolutely. Yeah, that would be a responsible way to act, in response to which I believe Henry Ford brought in gangs of thugs to beat the daylights out of them. But, I mean, these things don't always work out exactly the way they should according to ethics. But anyway, I just thought I'd mention a little bit about the concept of strikes. Yeah, unless you have any other questions about it, we'll go on to some other material here.
When a group goes out on strike, does somebody sit down and say, now, we're going to have to see if this is justified in any way, or does this fit the double effect standards, or?
No, sister, you're supposed to do that before you go out on strike.
Well, that's what I meant, like,
Okay.
as they're going to go on strike,
Okay.
somebody's sitting down.
Well, they ought to be doing it if they want to do it ethically. Again, this is the real world we live in. People do what they do. You can't make them act ethically. Most people aren't going to be digging out Higgins and start going through it to determine whether
So
it's
in other words,
licit to
there's no
proceed.
written kind of clause or something that says you have to consider these elements before you can go on strike?
Well, the
The
only,
ones that you listed,
well,
Higgins agreed with that.
yeah, you'd have to, pass a law saying everybody has to study Higgins before they can go out on strike. It doesn't happen. I mean, you may have certain labor relations laws that are aimed at encouraging this sort of thing, like, I mentioned things like mediation or arbitration or cooling off periods. The government has a role to try to promote the application of ethical principles. That's a perfectly legitimate function of government. The problem is that in some instances we find the government getting involved in trying to force unionization by permitting things like dues checkoff, wherein people's dues are being used ultimately for political purposes. I mean, there's 1,000 ways you can misuse the system, and it can be abused and misused by employers, by employees, and by the government. As long as we have human nature and original sin, somebody's going to find a way to misuse ethical contexts. But our concern is to find out what are those principles, and hopefully, if you ever get the opportunity, to bring them to bear in a context where you find yourself about to go on strike. I don't know how many of you are still in a position to go on strike. I'm not, but.
What is the role, during the war, my dad worked at either, I don't know if this was Curtis Wright, he worked at both, or Bell Aircraft. And he was going to work under pressure because he had to wear a hard hat to go in and to drive in, and then they use the word scab. And I don't understand how that fits.
Well, all right, what it
My
is.
dad was a good guy.
When workers go on strike, one of the things that the employer may do, because it's in his interest to try to keep the business going, is he will hire other people who are willing to come in and perform the function, keep the factory going.
He was from that factory.
He was from the
But
factory.
he had a different job, I think.
Oh, okay, well,
I'm not sure.
all right, look, if you're in a company which has multiple divisions, and one of the divisions goes on strike, and you insist on continuing to go to work, yes, the ones that are on strike will get very angry at you because you're enabling the facility to continue to function. And they'll call you a scab because, after all, a scab is what goes over an open wound. Also, workers that are brought in to replace the striking workers will be called scabs, and worse than
Was
that.
his action ethical?
To continue working depends on the context. I would tend to say that it probably is, because it wasn't his strike. But, the people that are striking and union members often are not very sympathetic when they're trying to make their point. Everything here, I hate
So
to.
they're causing injury, so their strike is invalid then, or illicit.
Not necessarily, but the means that they're using may be illicit. I mean, it's like if you're engaged in a just war, but one of your divisions is doing some things it shouldn't do, doesn't make the whole war unjust. But if you're conducting the war, you have an obligation to try to make sure that the people under your command follow the natural law. Similarly, if you are conducting a strike, if you are the union that is organizing and conducting the strike, you have an obligation to make sure that your members do not violate natural law, which they probably will anyway.
But you indicated that to be just, it should cause no injury.
It should not be planned to cause injury. If you're conducting a direct strike and part of your organizational efforts are flattening the tires of all of the management, that would not be illicit. Does that make it illicit that you strike? No, but it makes it illicit the way you're striking. And if that's the only way you know how to strike, I guess it would be kind of illicit. I mean, many things have been taken to be ordinary and common, and, like they say, all's fair in love and war. But it isn't. The whole point of natural law is that not everything is fair. But human beings don't always go by the natural law. We're in the world, but we didn't make it. What we're trying to understand is how it ought to be done. And if we're in a position where we can influence how things are done, it's our obligation to try to make it occur according to natural law. But that doesn't mean people are going to follow us. I mean, we live in a country which is violating natural law right and left with respect to the right to life and euthanasia and sterilization and a million other things. But we can't simply exit the country. If you do, you'll probably go to another country that's as bad or worse. So how do you live ethically in such a context? That's one of the great difficulties we have today. It would be far easier to live in a country that was operating according to natural law. It would be easier for our own consciences. Unfortunately, in life, we're constantly getting put into what we call binds of conscience, and things we don't ask for, embarrassing, difficult circumstances, where we wonder, what should we say to somebody? Are we morally obliged to warn somebody that they're doing something immoral? And how far should we go in doing this? This is always difficult. And that's why we have the virtue of prudence, which tells us how to go through life without violating our basic principles and also not getting beheaded. It's not difficult. I've often thought that the patron saint of lawyers is St. Thomas More. And look what happened to him. I always wondered whether they got the right saint. He wound up being beheaded. He did the right thing, but it would be nice to have seen things turn out a little better, but sometimes that's what has to happen. Okay, anything else on that? Otherwise, I'm going to go back to the notes, because we have to finish these up as we proceed. And some of this is redundant, which is why we're probably going to get to the end of the course faster than I would imagine. If you look on page 49, section 24 is simply a restatement of the definition of law. It doesn't hurt to remember that it's an ordinance of reason for the common good, promulgated by him who has care of the community. An ordinance of reason, remember, means that it's in accordance with right reason applied to, in our case, human nature. And remember, we distinguish between divine natural law that is unchangeable and universal according to human nature, and positive law, which we make up arbitrarily, but which cannot violate natural law in order to be licit. We use reason to devise ordinances which are for the common good, but they are not licit unless they are promulgated. And remember, the natural law itself is promulgated how?
Being written for us.
Yeah, by God giving us reason with which to, as it were, look in a mirror and reflect upon our own nature and realize what's appropriate to that nature and what is not appropriate to that nature. So the natural law is promulgated. Positive law may not be promulgated in some instances. I mean, if you get a traffic ticket for going 40 miles an hour in a 25-mile-an-hour zone and you can prove that there wasn't a sign, you ought to be let go because it wasn't promulgated in that context for you. And notice it also says, although it's not listed in the definition, with sanctions. You need sanctions in order to make law work, positive and negative. Positive sanctions, in other words, rewards for doing the right thing, the reward for living according to natural laws, ultimately to attain God as your last end in the next life. The corresponding penalty is you don't see God in your next life. You see other creatures, or they see you, as the case may be. But even in terms of positive law, how could you reasonably expect society to function well, especially in light of the fall, if there are no sanctions for misdeeds? So we give incentives to people to obey the law, and more frequently we give them fines and prison and those sorts of negative sanctions if they violate the law. All right, let's go over to page 50. Under B here, remember too that law is intended to protect people, not to burden them. I know we live in a society where that's a bad joke because we are hyper-regulated. One of the big problems we right now have with our economy going in the tank is that we have too many regulations. Businesses cannot thrive when you over-regulate them. And that's de facto what we're doing. I realize some people say, well, we need more regulations, but it's too easy for legislatures and administrations to invent regulations to apply to people up to the point where we now are, namely where businessmen do not feel like they want to do business. It isn't worth the hassle. And many of them, in fact, I know full well, are preparing to simply go out of business unless things turn out well in November in the American elections. This is amazing because that should never be the case. It should never be something that one would worry about. And remember, one of the regulations that one has to be careful about is taxation. The power to tax is the power to destroy. If you raise taxes too high, you are inviting people to stop working, which is counterproductive to society. We had our good friend, Monsieur Hollande, over in France, just raise the highest income tax bracket to 75% since he got elected. This is amazing. I believe the Swedes some years back had it up at 90%. And of course what happened is people just quit working. What's the point? There really isn't any. But anyway, to go back to the history of laws, some of the first laws we hear about would be the Code of Hammurabi, which goes back to 1000 BC. It's not listed here, but we have the Roman law, which of course was universal, at least as universal as it could be. It created the Pax Romana, a peace where of course everybody submitted to Rome. That's how you had peace. And you codified things a priori. This is not the same thing as what we see developing later on in the terms of the English common law, going back to the Magna Carta and thereafter, where judicial experience, trial and error, precedents developed a code of law which was tried year in, year out, century in, century out, until it built up a substantial body of law based upon the common experience of British jurisprudence. Conversely, we have civil law, which was developed as, it says here, a perfect system deduced by reason ahead of time. Specifically, one thinks of the Napoleonic Code, which was, in a way, a fantastic achievement, because they simply sat down and wrote out a body of laws a priori, not based upon experience, but based upon how things ought to be, and that was carried on, of course, even to this day, in some extent, in Quebec and Louisiana. And of course, primarily in France. I remember when I was living in Louisiana many years ago, wanted to draw up a will, and you had to find a local attorney to do it, because they drew up wills differently than you would draw them up in other states, because they were operating according to what was basically the Napoleonic Code. A different way to do it. And it's not saying which one is better, which one is right, but these are simply different ways to use reason to develop a judicial system. Even within law, there are conflicting traditions between a natural law system of law, upon which in some measure our country was based, and what has today become a completely positivistic set of laws. If you go to law school today, the only thing you're going to get is positive law. It's whatever's written down, and ultimately it's whatever the judge says it is in a given case. I remember one instance I heard of where a lawyer walked into court and thought that he had the case absolutely slam dunk won because he quoted to the judge his own precedent. And the judge said, "Well, I overruled myself." What do you do? What do you do? One of the problems that we're concerned with today, too many laws, proliferation of laws, an attempt to legislate for every case, creeping legalism, so you have literally tens of thousands of laws, arising because of nominalism in the context of law. Remember the conflict between nominalism and moderate realism. Moderate realism recognizes that there are universals. And when you're enacting a law, you ought to try to capture in as brief and concise a fashion the very essence of what it is you're trying to define. And say no more. If you say much more, what happens, of course, is people say, well, what about this case? What about that case? And then, of course, the legislature comes along and says, well, we better change the law to fit this case. And you fit this case, and suddenly something else doesn't fit over here, because especially if you haven't conceptualized it properly, you're going to have concepts that don't fit together perfectly, and the only way to fix that is to pass a law for every possible case. And that's why you wind up with 10,000 laws. What you're supposed to do is have clear laws, simple laws, sufficiently articulated so that they cover every possible case that could arise, and that's what, believe it or not, judges are for, and even lawyers, to help discern the truth, according to this universal properly understood. So you need to have enough laws to govern effectively, but not so many laws as to get in the way of what you're trying to achieve by legislating. We also have to distinguish between the spirit and the letter of the law, because sometimes the letter gets in the way of the spirit. If you are told you're not supposed to run a red light and you're trying to rush somebody to the hospital, it may be necessary to do it. But again, reason tells us that you can't do that arbitrarily. I remember, it wasn't too long ago, and you do remember too, used to be that the police, if they were going somewhere, just turned on the siren and went. And they'd run through a red light, 70 miles an hour. I remember 30, 40 years ago in Dayton, Ohio, coming up to a light that I had green, and I had a radio playing, and I didn't realize what was going on, and all of a sudden, a police car shot across in front of me at about 70 miles an hour. I never heard him, didn't hear his siren. So you could have innocent people getting easily killed. So again, I ran into a circumstance just a few days ago where I was coming up to a red light, and I saw an emergency vehicle coming up to the light, and although he had sirens and lights and everything, when he approached the light, he slowed down so he could have stopped if he had to. And even in case of an emergency, prudence requires that we do this. And even if you ultimately run through a red light because you're trying to save a life, you got to look both ways first. Yeah, at least it helps. Okay, and of course, point E, we need sanctions in order to enforce the law, which leads us back to the question of punishment. And I realize we dealt with this before, and one of the things we're going to get to in about a page, 2 pages, no, 1 page, we're going to get back to looking at capital punishment again. And we already covered this in great detail, but there may be a few highlights that we might want to look at a little bit differently, especially because we dealt with it very early in the course, and now hopefully we know more. I hope I know more. So maybe we can find something we didn't see before. Here we have St. Paul quoted as saying, "The avenging minister does not carry the sword in vain." Well, okay, I guess that's a scriptural foundation for the use of corporal means of punishment if need be. People often misunderstand the function of punishment. It's not lex talione, it's not the law of retaliation as sometimes it is understood, but the notion of a punishment is that the punishment should fit the crime. And I know I gave you this example before, but it's well to remember. If you're just thinking of punishment as preventing people from doing the wrong thing, you can deter people from doing the wrong thing by having a very strong punishment, but it doesn't always make sense. For example, we could say if you park in the wrong place outside the hospital here, we will have you executed. You probably won't park in the wrong place, but is that right? Is that a legitimate punishment? Conversely, we might say, well, if you're a serial killer, we're going to give you 30 days in jail. Now, that doesn't seem right either, does it? So you can see, just from those extreme examples, that there needs to be a gradation in punishment. The punishment, that's the whole notion of the punishment, should fit the crime. Lesser punishments for lesser offenses, larger punishments for larger offenses. You know, don't have to be a genius to understand this. And of course, the ultimate punishment we think of would be capital punishment, and we've talked about it before, but as I say, we'll come back to it again. There are three purposes or ends of punishment. Retribution, remember, we don't even really like the word retribution. What we really mean is retributive justice, not to be confused with revenge. Retributive justice restores the balance and order to society which has been violated by the lawbreaker. So if someone has killed someone, you don't just say, well, yeah, that's too bad, he really shouldn't have done it. And we'll go on with ourselves, and on top of that, we'll tell him he shouldn't do it again. Well, obviously, there is no respect for law. There is our minds, our gut reaction cries out and says, wait a minute, you can't do that. This person has to be punished for having violated the law, and it should be proportionate to the deed that he has committed. So the notion of retribution is that there, you know, like you think of the blind lady with the scales, you know, that the scales are out of balance. Somebody's done something wrong. They've put things out of balance. If you steal something, you have to give it back to restore the balance. And a person who has grossly violated natural law or positive law in society has disturbed the order and balance that is supposed to be present in society. Something has to be done to correct them. And that's where the notion of punishment comes in. I mean, what are you going to do? Give them a reward? Hardly. Now, in addition to retribution, we have both the notion of correction and deterrence. But it always is to be understood that correction is not of the essence of law. By correction, we mean we will rehabilitate you, so you'll be a nice guy going forward. And many people have thought that's all there is to law. People have done misdeeds. Maybe they can't help themselves. That's where you have people coming out saying, well, you were raised in a bad family. You inherited bad genes. That's really not your fault. We got to do something with you, so we'll retrain you. The difficulty is, of course, there are people that are raised in a bad neighborhood who have horrible genes, and they still don't become serial killers. We have a factor in there called free will. But indeed, correction is a good thing, undoubtedly. But it is not of the very essence of punishment. It's something attendant to it once you have been found guilty of a crime and are being punished. Then if we can correct you, fine. If we can't correct you, fine. I mean, it still stands. And as St. Thomas points out, if knowing for sure that you're going to be executed doesn't correct you morally, I don't know what will. But it doesn't guarantee that you're going to be put back into society, patted on the head, and said, go ahead with what you're doing, because some crimes are of such a nature that you have to be removed from society permanently, one way or another. We'll talk about the one way or another later on. And of course, deterrence. As I say, if you park in the wrong place, we could execute you. That probably would deter other people from doing the same thing. But the point is, it isn't a just punishment to you. You don't deserve to be executed for such a minor offense. I'm trusting it is a minor offense. And not that you parked there so you could blow up the whole hospital. That would be not a minor offense. So, yes, I cannot punish you in a horrific manner so that someone else will not commit the same crime. It may be that your punishment for your horrendous crime is bad enough that others will be deterred, but that's simply a happy side effect of the punishment. It cannot be the reason for the punishment. So correction and deterrence are side issues. The main purpose of punishment is to restore the balance and order in society through retributive justice. The power of punishment follows upon man's nature. Why? Because man, by nature, is ordered to society, and society is ordered to self-government. In other words, if you're going to you get a group of men together, they naturally form a society. Society means you have certain rules. Violation of the rules entails punishment. Having the rules means self-government. So it is right in the nature of man, collectively, when he joins together, you remember, you start with the conjugal society, husband and wife, the familial society, husband and wife and children. And then when you begin to put a number of families together, you might have a tribe or a village. And indeed, you're going to have village ordinances when it's licit to put your garbage out to the curb. You've got to have some rules so you don't stink up the whole town. And the requirement of having these rules entails the ability to punish those who violate the rules, ultimately even to the point of capital punishment. Now, because it is a natural institution, there are certain authorities that issue to the society that an individual doesn't have. That's why you or I don't have the right to have capital punishment towards our neighbor. Self-defense, yes, but society as a whole can adjudicate a criminal to the point of determining execution. Society as a whole may determine that a criminal can be put in jail for the rest of his life or for 10 years. You or I as individuals don't have that right. So the fact is that God has given to society as a natural institution certain powers which the individual as an individual does not have. But again, of course, the positivist isn't going to see that. Positivist is going to say, well, society isn't a natural institution. It's just based on a social contract. But the difficulty with a social contract is, how could a government obtain the right to execute when you or I, as the parties forming the contract, don't have that power? We can't get something out of the contract we can't put into it. So if we don't have that right as individuals, we could never give it to society as a whole. But society as a whole does have that right. Therefore, it's getting its right and its powers from something more than merely a contract. The contract determines the form of the government, but it doesn't determine the formal content of the authority of the government. That goes from the very nature of being a government of a state or nation. And a couple further points here, again, to follow the notes. It's not an evil act to kill a man, only to kill an innocent man. If it were an evil act to kill a man, you could never defend yourself, even to the point of killing someone. So that the question of innocence is all important. You could never defend yourself against an invading army because you might have to kill them. See, that would be, you'd be killing, of course, they're not innocent. That's the point. And of course, we have the example of Abraham and Isaac, misspelled, there's two A's there, where God ordered Abraham to kill Isaac. And one might ask, well, how does that prove anything? Well, because he didn't have him actually do it. The angel stopped Abraham at the last moment, didn't he? But the point is, God would not order him to do something that is intrinsically evil. That would not be appropriate to the nature of God. I like the next point. Animals don't seek revenge. Only man does. You stop and think about it. They're beastly. Yes, they do terrible things, but they're far better than we are because They can't help themselves. It's just their nature. We may have to shoot them because they're attacking us, but when a dog comes up and bites the postman's leg, you don't look down and say, "You reprehensible cur, how could you do such a thing to me?" You know how he could do such a thing. He's a dog. Dogs do this, just like they chase after cars. Also, note point number 3, the anti-capital punishment neurosis is an anti-Christian emphasis on this life, because what it's saying is the ultimate and only value is life, and therefore you just can't take it under any circumstances of capital punishment. Of course, you and I both know the irony of that, because these same people are happily willing to take life in the case of abortion or euthanasia, where their entire value system is askew. All right, again, we have the authority as a society to protect the common good, but not to injure the private good. I think that stands as evident. Let's go to page 51. Just kind of a basic principle here that often gets missed, and I think I mentioned it at the beginning of the course, but I'm sure now you would understand it more fully. Judgments of ethics with respect to punishment, as well as other matters that are normative, belong to philosophers, not to political scientists, not to criminal justice specialists, not to sociologists. Have you ever noticed how many times the TV will bring in a sociologist to determine what punishments are appropriate, or to determine whether something is right or wrong for society? They really can't do that. Political scientists can't tell you who should win an election, because in order to know who should win it, you have to know which values should be affirmed. Political scientists can tell you who probably will win an election. That's their proper function. Or to analyze the inner machinations of different forms of government, how the various agencies interact with each other. But when you're talking about not what is, but what ought to be, you're in the realm of philosophy. You're in the realm of ethics. You're in the realm of theology or moral theology or pastoral theology. Philosophy is a normative science. It deals with what ought to be, just as pastoral or moral theology deals with what ought to be, how we ought to behave in order to get to heaven. Ethics tells us how we ought to be to live as a full human being in order to attain our natural last end, which we know to be God, even though we don't fully understand how this will be attained in the afterlife. We know there's an afterlife from philosophical psychology, which demonstrates that there is an afterlife. The social sciences, though, are descriptive sciences. They simply tell us what is. It's the old is-ought dichotomy. How do you go from what is to knowing what ought to be? In fact, there are some philosophers who have argued you can't do that. That's why there's no ethics. But you can go from the is to the ought in this sense. God has created us to be in a certain way. And we have to be that way under penalty of not being at all. When I say not being at all, I mean being distorted from the perfection, from the enjoyment of being what a human being would be. And for layman's terms, going to hell. The social scientists describe how things are, but the problem is, in the positivistic milieu in which most of them are speaking, there isn't any value. There's no value system. If we're nothing but a pile of atoms that have evolved over billions of years to this automaton that's presently walking the earth and will shortly be dissolved back into the dust with no afterlife, what are you doing talking about how things ought to be? There are no oughts. There are no oughts of any type. And really, they should simply stop talking about the way things should be. They shouldn't even be telling you which system of philosophy you ought to follow. Because if I want to follow total falsehood, that's my business. I guess that brings us up to the question of capital punishment once again. So I think I'm going to stop here because that's getting into a new topic, which would probably go a bit too far. So we'll stop there.
This set of philosophy lectures is produced and distributed by Olting Library Services, 2316 Delaware Avenue, PMB 325, Buffalo, New York, 14216. Please visit our webpage at www.aquinasphilosophy.com.